Awesome.
There you
Thank you. Well, thank you everyone for coming along this morning. What we're talking about today as part of our construction lockdown series is running through director's duties. I mean, one of the big questions we get put to us is around roles, responsibilities and duties as a business owner. And we've had that come to us a number of times this week already, just because people are thinking really critically about what it means, essentially being told to shut down their business for 2 weeks, and what that's going to mean to them and their obligations as a business owner or director of that company. So I'm really fortunate to have some excellent people out of our team here this morning. So Sally Bates and Georgia Marjoribanks are both senior lawyers in the Morrissey law team. They'll be running through a lot with you, but I'm also really excited to have a good friend of mine and probably one of the best accountants I know, Dan Mills, in here this morning speaking with us. Dan's Director of Business Advisory at William Buck. I've been fortunate enough to know Dan. I was working out this morning, Dan. We've known each other now for 16, 17 years. So it's been a long stint, but no, Dan's excellent and is really good at giving some practical and commercial advice. I'm about to disappear off the screen. What I'll be doing is monitoring questions in the background. So if you do have any questions, use the Q&A feature, put up your hand, whatever it might be, and we'll cover some of those things at the end. But I'll throw over to you, Sally, Georgia and Dan. Thank you.
All right. Hi, thanks, Mike, and hi to everyone. Hi, Dan. It's been a while, I think maybe a year. It's gone quickly. So just housekeeping, this is recorded, so you'll be able to go back and rewatch and re-listen. If there's any little bits and pieces that you want to revisit, you'll be able to do that. And as Mike said, if you've got questions, probably pop them up in the chat. We might deal with them if they're relevant at the time in the presentation, or we might leave them to the end, or if Mike knows the answer, he might shoot the response back in the chat as well. So any questions you've got, pop them in the chat, or you can ask them at the end. So basically today we're going to be looking at director's duties. So if you're a director of a company, you'll have rights and obligations under the law, and these are often referred to as the director's duties. That's the kind of colloquial term that we use. And if you breach those duties, there are some pretty serious consequences to consider. Obviously, there's some really interesting things happening at the moment with COVID and the construction shutdown in particular. And these sorts of things could impact on your ability to comply with your director's duties. So, during these tough times, it can be difficult for you as a director to put the interests of the company ahead of your own interests, especially, when things are disrupted. It's hard to keep up cash flow. It's easy to kind of slip up on regulatory obligation. Things are changing all the time. So it's a bit of a stressful time for everyone. Which is why we thought this kind of refresher session would be really helpful. And this afternoon, we're also going to have a session, Matt Bryan from our team and Chad Rapsey from Rapsey Griffiths. We'll be going through insolvency, safe harbour provisions, and how you can kind of protect yourself against some of the sort of key legal and financial risks during this lockdown. So that's at 2 o'clock today, if that's of interest to you. Today, we're going to look at who the director's duties actually applies to, what the duties are, why it matters that you comply, and some tips on how you can get it right.
Okay, so let's start with that first question. Who is a director? So most companies will have directors who've been validly appointed as a director by shareholders or other directors. Their name shows up on ASIC searches. For those people, it's really clear. They're directors, they have directors' duties. But it's important to remember that you can still be required to comply with directors' duties in certain circumstances, even if you haven't been validly appointed. And that happens when you're sort of acting as a director anyway. So if you're showing up to directors' meetings and making decisions about the company, you might be what the law sees as a de facto director. So the paperwork hasn't been set up, but in practice, that's the job that you're doing. Another way you might be considered a director with duties, even though that valid appointment hasn't been made, is if the board of a company is following your wishes and deferring to you when they're making decisions. So while you're not named in ASIC paperwork, you're sort of effectively the person who's actually calling the shots. So that in that scenario, you'd be considered a shadow director, and you might still have some obligations. Another scenario that we see relatively often is somebody who has been validly appointed as a director on paper, but they're not really involved in the day-to-day decision-making of the company anymore. It comes up fairly often in family businesses where perhaps a parent might have started the business, but now it's their children who are running things, but the parent's still a director of the company. So in that scenario, that parent might be a silent director. And it's important for them to realise that they still need to be across their director's duties as well, right up until the day they stop being a director. So I'll throw to Dan from William Buck just to talk about the things he sees out in the real world when people aren't quite clear on who the directors are and who's doing what.
Thanks, Georgia. I think on that silent directors piece as well, it's an interesting one because that is one of the biggest furphies that's out there. People think, well, I've got my name on the ASIC form and it's mum's company or it's dad's business or whatever it might be. And think because they're not involved in the day-to-day, maybe they just sign a set of accounts once a year, that they don't have the obligations, but you absolutely do. And I think one of the things that I see, particularly in the construction industry, is there's often, there's various, I'll call them excuses or reasons as to why people add other people as a directors. So I had an example of a new client that came on board kind of early this year that had a number of just genuine employees as directors, like a significant number. And that just astounds me because those people there are bringing themselves a whole host of personal liability. They don't have access to the information that they need to have access to as a director. There's a whole host of issues with that. So, one of the key documents that comes around every year is that the ASIC annual review statement, where all the directors are required to sign a solvency resolution and also to confirm that the details of directorships are up to date. With DocuSign, it's easy just to, that sort of gets fired out and you just click sign. That is actually really important. And I would suggest that 12 months is a really good health check when that comes through, that you're saying, well, should I actually be a director of this company? Do I know where it stands? Do I know what the financial position is? Am I comfortable with it? And if you're not, should you be doing that?
Awesome. Thanks, Dan. So obviously directors have all sorts of duties. They're duties to the company, there's duties to the shareholders of the company, and the sources of these duties they're found in a few different places. So one is the common law, which is kind of all the rules that have been developed out of court decisions in the past. So common law is the law that's made by judges, essentially. There's the Corporations Act, and that's sort of the key piece of legislation that regulates companies. It's obviously not the only one, but it's kind of the key one. It came into force in 2001, gets updated constantly. If you have a printed out version like Georgia and I have had in the past, it's like about that thick and wafer thin pages. And your company documents, so things like your constitution and shareholders agreement, will also have some specific duties for directors in there. You might have a written constitution, or you might just be regulated by a pretty standard set of rules that is set out in the Corporations Act. Some companies have shareholders agreements as well that will have different things in there. And then there's obviously all different types of other legislation that we'll touch on briefly later that could impact on the types of duties that you would have as a director. There's two broad categories of directors' duties. So the duties are pretty vast. There's often a lot of overlap, but we like to break it down into kind of two main areas. One is to act with loyalty and good faith, which is more of like a personal responsibility. So acting honestly, acting in the best interest of the company. And then on the other hand, you've got duties to act with care, diligence, and skill, which are more professional responsibilities. So informed decision making in relation to the company. So they're broadly the two main types of directors' duties that we're dealing with.
All right, let's jump into that first category. So when we talk about the duty to act with loyalty and good faith, we're sort of referring to a bundle of different obligations that you have as a director, which we've listed out on the screen there. So you've got a really clear duty to act in the best interests of the company. You have duties to only use your powers as a director for a proper purpose and not sort of gain some personal advantage out of the role. You've got obligations to consider decisions on their merits and think about what's going to benefit the company as opposed to what might benefit you or family shareholders or anyone else with an interest in what's going on. You have duties to avoid actual or potential conflicts of interest or to disclose those conflicts when they come up. You've got an obligation not to misuse the information that you get as a director to gain an advantage for yourself or for someone else or to cause any kind of detriment to the company. And you've also got obligations to obtain approval from other shareholders and different stakeholders in certain situations. So before making big financial decisions, or slightly different in every company, but there's often restrictions on what the directors can do on their own and when they need to go and get further approvals from other people interested in the business.
Okay, so let's have a look at how some of these duties of loyalty and good faith would play out during this lockdown period. So it sounds simple, act in the best interest of the company, but it can get a bit complicated where one person is kind of wearing a lot of hats. It's pretty common in small to medium businesses for the same person to be a director, employee, and shareholder all at the same time. But it's important to remember that all of these positions have different rights and responsibilities. The issue with the director's duties is that you need to be careful about what hat you're actually wearing and when. And if you're acting as a director, then your primary duty is to the company. So, for example, you're doing it tough financially. It might be tempting to take out a loan from the company or bump up your own remuneration during the shutdown. But that could be a problem if you've removed funds that the company actually really needed to pay its own bills. So there's a bit of a tension there. And another example could be with welfare payments or government support schemes. So hypothetically, if workers were stood down for 21 days or more, if that entitled them to payments from the government, you could find yourself a bit conflicted. Like your company might be ready to return to work, business as usual on day 14. But if you're a director and an employee, you might think, oh, if I keep it closed for another week, then I can access all of these government benefits as an employee. But in that sort of situation, you're kind of using your position as a director to game the system, which could be a breach of your director's duties. You may not be acting in the best interests of the company in that situation. You might be misusing your position as a director to gain a personal advantage to the detriment of the company. So it's just something to keep in mind during the lockdown, who you are, what roles you have, and how you're making decisions.
All right, now we've been through that first category of duties. We'll look at our category number 2, which is that duty to act with care, diligence, and skill. So as you can see on the screen, there are a lot of the duties in this category relate to keeping track of the financial position of the company. And others are about just having the right skills, acting professionally, and complying with the regulations that affect your business, which might be slightly different for everyone on the call. So some of your obligations in this category are to be informed about the company's financial position, including that point about whether the company is able to pay its debts as and when they fall due. And as Dan pointed out before, these duties apply to all the directors. So it's fairly common for a board to have people with different areas of specialty. So you might have one director who focuses on business development. There's somebody else who handles the HR side of things. And then there might be someone whose job title is CFO, and they're sort of the go-to for all things financial. So it's really important to remember that if you're a director on a board like that, you can't get out of your duty to monitor the company's financial position by saying, oh, that's not my area, we've got somebody else looking after that. Everyone on the board needs to keep track of how things are going. Because you've all got that obligation to ensure that the company is not trading while it's insolvent or where you suspect it could be insolvent. So again, insolvent just means you can't pay your debts as and when they fall due. And debts could be anything from a loan repayment to equipment rental fees or any other invoice that's coming in. So monitoring your solvency is going to be especially important during this lockdown because many of you are still going to be incurring all the usual expenses, but you won't have the same amount of cash coming into the business. So you might be finding yourself getting a bit closer to that line than you would ordinarily be. Another duty you have is to consider the company's financial position before you incur a new debt. So as I've mentioned, that debt could be anything from a new contract or a new invoice or any situation where you're promising to pay someone. So again, if you've got any doubts about the cash flow and how things are tracking, it's really worth really carefully considering whether you need to be signing up to these things now or whether you can hold off until things have stabilised a little bit. And the session this afternoon is going to go into a bit more detail about how you can sort of manage that financial side of things. And finally, you've got obligations to ensure the company keeps up-to-date and adequate financial records and complies with reporting obligations to ASIC and other regulatory bodies. So one, you have to do that because it's the rule, but secondly, having those accurate up-to-date records will make it much easier to comply with all the other obligations on this list, because if you're able to see how the company is tracking in real time, you'll be able to make decisions with so much more confidence. Because if you're relying on figures from, say, 30 June or some period before the lockdown, you don't really have an accurate picture of what's going on now. So again, I'll hand back over to Dan to chat about sort of some of the warning signs you might be seeing in your business or red flags that might tell you that you're getting a little bit close to that line.
Yeah, so I think we always look at these from kind of both sides of the coin, right? If you had some of your debtors or your customers and you were seeing these trends, that's a worry that maybe you know who you're dealing with is not in a great position. But also, you know, on the same side of it, if you're a director, you know, and you see that the business is starting to have a few of these red flags, you know, that's when you need to start asking the questions. Yeah, so some of the you know the common warning signs that we see is obviously, you know, receiving some nasty letters from people that you're behind on your payments. You know, difficulty meeting loan repayments. You know, or you know, I guess moving into the hospital section of the bank. You know, or the bank's starting to ramp up, you know, their activity there is always a worry. Legal action, obviously cash flow is kind of the main one that people are going to see as the beginning one. Trade suppliers requiring cash on delivery, and then missing your lodgement deadlines for PAYG, workers' compensation, GST, those sort of things. They're kind of the big warning signs. And I think just back on the importance of the director piece as well, and the importance of that role, the most common way of people becoming a director is consenting to act as a director, right? So the ASIC form comes out and you sign it and say, yes, I consent to act as a director. What everybody should be doing beforehand is asking for the information. You have a right to ask for that information and reviewing that information and making sure you're comfortable being appointed. One of the things that people, I think, kind of don't place enough weight on is if I was to consent to act as a director, but I knew nothing about the company, right? I've essentially got 30 days before I become personally liable for all of the GST, all of the PAYG, and all of the superannuation, personally liable for all of that. And it's not good enough for me to, a director, then get access to the books and go, oh, I don't like this, I'm going to resign, right? Because unless I do something about it, so unless I appoint a restructuring or start the wind-up process or get those debts paid, you're personally liable. So it's a really big thing, and I think a lot of people don't give enough weight to it. And I can talk about a few war stories when we kind of get to the end of the Q&A piece as well. But I think, you know, it is really, really important. And one of the silliest things I see is people just going on there because it's for a, you know, it was easier for a tender process, or it was easier to have this guy that was on site that was able to sign things. That is madness. And it's kind of two-sided, right? If you're a shareholder or the owner of the company, you don't want people being directors that shouldn't be directors. And on the same side of things, if somebody comes and says, hey, would you like to be a director of my company? Unless I'm actually going to be involved in it, reviewing it, understanding the day-to-day operations, then your answer should be no.
Awesome. Thanks, Dan. Okay, so now we're just going to have a quick chat about the business judgment rule. So if there's sort of a claim that a director has failed to act with that care, diligence, and skill, you may be able to defend yourself using this business judgment rule, which basically acknowledges that no commercial decision or action is ever certain. Even well-intentioned decisions can mean, you know, resulting in loss or financial difficulty. And it doesn't make any sense to punish directors for making informed and careful decisions just because those decisions in the end didn't end up being the right one. In the current environment, you know, obviously it's really important to know your obligations and do your absolute best to comply with them. It's also likely that, you know, courts will understand that these are really strange circumstances. Things are changing at a rapid pace. Information from the government about what you can and can't do is constantly changing. So if a decision that you make ends up being the wrong one down the track, and you find yourself trying to defend that decision, you know, the court can consider things like, you know, can you rationally explain how you arrived at a decision? Did you have information at the time which kind of justified that decision or made it more understandable? Did you get advice? Did you carefully consider the decision and its risks in meetings and discussions? And can you kind of prove that in paperwork or emails, things like that? Did you have any personal interest in that decision? And did you have any sort of safeguards in place to address any potential risks with that decision? And if you can kind of tick a lot of those boxes, then it's likely the court will say, look, you exercised your best, you know, business judgment in those circumstances, despite the fact that whatever decision ended up being the wrong one. And that can help you avoid sort of personal liability for breach of a director's duty.
All right, so now we've been through what some of those key duties are and who they apply to. We'll talk about what happens if you do breach the duties. So at a really high level, if you breach your duties as a director, you could potentially face civil penalties, which is fines issued to you or the company, jail time in really extreme cases. You can become personally liable for paying off some of the company's debts or other costs that you've created by acting in breach of your duties. You can also be disqualified from being a director of the company that you're in now and other companies in the future for a pretty extensive period of time. And depending on the paperwork sitting behind your company, the shareholders in your company might have a right to remove you from the role if you are not complying with those duties. So because we're in lockdown, let's also talk about what happens if a company breaches a public health order. So again, the big picture, breaching a public health order is an offence for individuals and for companies. The maximum penalties for individuals can go up to $11,000 or an extra $5,500 per day if there's a breach that's continuing over a long period of time. Individuals can also face up to 6 months imprisonment in extreme cases. When it comes to a company breaching the orders, the fines jump up to a maximum of $55,000 plus another $27,500 per day for continuing offences. There's also on-the-spot fines, which range from sort of 1 through to 4K for things like failing to wear masks, breaching travel restrictions, giving false information to enforcement officers. So it's a long list of fines, and obviously you want to avoid those costs, especially during this lockdown. So it's really worth keeping as up to date as you possibly can with the health orders. We appreciate it's difficult because they're changing all the time. The New South Wales Health website, New South Wales legislation website are really useful. All of the panelists on the call here are also happy to help wherever we can. That's what this webinar series is all about, to try to help you keep on top of things. So reach out if you've got questions, is the message there.
Okay, so we've talked about directors' duties, we've talked about consequences of breaching the directors' duties, and about public health orders. But there's a little bit more, as I kind of referred to earlier. There's other pieces of legislation that could apply to your business, and making sure that you are aware of that legislation and its sort of implication on your business is part of acting with care, skill, and diligence. So in some pieces of legislation, it may specifically provide that, you know, if a company breaches that legislation, that the directors or other people sort of with management control can actually be personally liable for the breach. So you need to start having a bit of a think about what legislation is likely to apply to you, and what sort of the consequences are if the company breaches that legislation, whether there's any implications on directors or people in the sort of management team. We won't go into too much detail on this because, you know, there's lots of pieces of legislation out there. All of you will kind of be operating in slightly different regulatory environments, but two examples in the construction industry in New South Wales are the Work Health and Safety Act and the RAB Act, which is the Residential Apartment Building Compliance and Enforcement Powers Act. So they're two pieces of legislation that might impact on some of you. And in those situations, fines can be issued to a company and to its directors for the same incident. And if it's issued to the company, then the company can pay it out of company assets. But if it's issued to you as a director as well, then you have to actually pay those out of your own pocket. So just be aware, other pieces of legislation might have implications on you personally as a director.
Okay, so now let's have a look at how you can protect yourself against some of those consequences from the last slide. So obviously it's much easier to comply with your director's duties if you know what they are and you've got really clear processes in place that make it easy for you to keep track of decisions and keep that paper trail showing that you've acted professionally and performed your role as director in accordance with all your duties. And we keep emphasizing that point that if you're not sure how your company is tracking financially, you're putting yourself at a greater risk of breaching those duties around solvency. Okay, but even if you do know your duties and you've done everything you can to keep the records up to date, things can still go wrong. So directors will often look at other ways of trying to protect themselves. So two of the main ways that a lot of the companies we work with use is firstly to have the company take out directors and officers insurance policies. You'll often hear these referred to as D&O policies. So those policies pay out to cover certain costs that arise when directors take actions that incur some kind of cost, or if there's a claim or an accusation that directors' duties might have been breached. So that's definitely something worth looking into if you don't have that sort of thing in place. And then the second related point is for directors to sign something called a deed of access, indemnity, and insurance with the company. So we'll just break down those three terms. So the first one, access, is all about the director having access to company information, financial information. So that goes back to Dan's point about making sure that if you're on the hook as a director, you've got a really good understanding of what's going on and you've got access to all the information you need to be confidently signing off on things like those annual reports at the end of each year. Indemnity, that second point. So often in these deeds, the company will indemnify the director, which basically means the company is agreeing to cover certain costs that the director might incur as a result of a breach or some other action that they've taken. So that might include things like legal fees if you have to go and speak to somebody about a potential breach, or travel costs if you need to be visiting advisors or attending legal proceedings or anything like that. And then insurance, that's just a link back to this directors and officers insurance. So it's an agreement by the company that they're going to take out an appropriate policy that will give you that little bit of extra protection. So on the insurance front, chat to your insurance brokers or business advisors. If you're interested in getting one of these deeds set up, we can absolutely help you with that. All right, so I might just again, before we go to the Q&A, throw to Dan to see if you've got any other war stories to share with us or just practical tips people can keep in mind over the next week or so.
Yeah, no, I think you covered most of that really well, Georgia. I wrote down 3 things here as you were talking. So summarising, all of what you just said basically is prevention is better than cure. So don't do the wrong thing and you won't get yourself into trouble. The big one is documenting any decisions that you make. So emails are fine, but if it's something that you really want to, you want to make sure it's documented properly, talk to your accountant, talk to your lawyers, make sure that you do a proper minute, do a resolution, whatever it might be, to make sure that it's recorded and you can say who was at that meeting, who's agreed, those sort of things. And then I've written something different here, but when the risk hits the fan, that's the time to go and speak to your advisors, right? Go and talk to your accountant, go and talk to your legal advisors, whoever it might be. If you join the webinar this afternoon, who I think Chad's talking at, he will talk a little bit about the importance of that and the importance of engaging advisors early and seeking advice. That is going to be one of your best protections because, you get yourself into a position there. And if you can go and say, as soon as I found out there was something wrong, I went and spoke to my lawyers and they started hand-holding me through what the process was, that is going to stand you in the best position, right? And then just in terms of war stories, I talked a bit about personal liability. They've slowed down a little bit, but we initially saw there was a bit of a run of directors' penalty notices, which is superannuation, PAYG, and then in 2019 they expanded that to include GST. So, basically unpaid tax debts, you could become personally liable for as a director. And we saw a decent run of those, right? And, where there was a history of non-compliance with, lodgements and payments and those sort of things, tax office didn't hesitate to put a heap of those out there. They have slowed down a lot. In fact, I haven't seen any since March last year. But, there's a whopping great debt out there and somehow that's going to need to be repaid. And that's where you want to make sure that you're fulfilling these duties that we talked about this morning, to make sure that, first of all, you're not going to get one of those. And second of all, if you do, that you've got yourself in a position where, you've got something that you can rely on there.
Awesome. Thanks, Dan. So now we're going to just open it up to some questions. Mike, I don't know if any have been added into the chat.
It's been a bit quiet, so I'm sure everyone's been listening very intently. I wanted to throw across to you, Dan. I think one of the things, and I don't have a clean answer to this, one of the things that gets raised from time to time is people don't know how to engage clearly with professional advisors. And I think lawyers, look, we can add a lot of value, but often we come into the Band-Aid moment. I would love to come in earlier, but accountants are on the front line, I suppose. They're at the coal face. I can work through a whole bunch of analogies right now, but talking generally, I guess people get an accountant. How should they look to be using them? Like the accountant's really the first person you're dealing with in terms of external business advisors. How can people meaningfully engage with the accountant as their number one business advisor, because you're the person that will see things first?
Yeah, look, and I think there's always going to be an issue of fees, right? People are always going to be conscious of paying fees to professional advisors. Sitting on this side of the fence, it's one of the best costs that you're going to have, right? Because the more that you can engage with, I could tell you countless stories, but the more that you can engage with your accountant and your legal advisor before a transaction, doesn't matter how big, how small, what you're doing, I guarantee you, without fail, every time, it is going to be far less expensive, right? So I do a lot of work in construction and property. The majority of my work is restructuring things or fixing big problems, right? So they could be problems with the tax office, problems with the way that, you know, an asset was purchased or a property deal was structured, trying to unwind that, trying to fix that up. That's kind of where you end up with problems. So I guess the way that you need to view that is more of a partnership. So people will often view their accountants and their lawyers, you know, well, I'll talk about accountants as, yep, you do my financial statements and my tax returns, tell me the big bill that I've got to pay at the end of the year, and then I'll see you again in 12 months, right? That's where you can run into a problem, because if you don't have that constant engagement, right, and that constant with somebody to have a look at it, to monitor what's happening, to be able to give you some of those insights that you may not see in terms of, hey, there's a few problems here, or this looks like it's about to become an issue, or you're really heavily weighted on this one client, we need to look at these other couple of things. That's, you know, you will get a lot of benefit out of doing that.
Yeah, I think that's really useful, because it's that people are afraid of asking stupid or embarrassing questions. You know, it's hard to do, but it's one of those necessary things. There's always generally been something that's been worse that's gone before, but the whole reason you've got those professional advisors there is to be able to give you that comfort, give you that answer, and probably give you that frank advice. Holding off asking embarrassing questions or something you're nervous about can that then sort of spiral a bit out of control. And I guess you're at the front line, Dan, so you are seeing, you are in a position where if people let you know things early, you can proactively work to fix that.
Absolutely, yeah. And look, I think as well, you know, so because it's property, I often will get the phone call of somebody sitting in a lawyer's office saying, I'm just about to sign this contract, and I've got it in this entity, whatever else, and I have 15 minutes to try and fix that up. We will work within that 15 minutes to get that right? And 15 minutes might cost you a couple $100 to get that fixed up. Doing it incorrectly and paying stamp duty and whatever else we've got to do to unwind it is going to be far more than that quick phone call beforehand. Yeah. And that's why if you have somebody that you're happy to talk to, that knows your business, that understands your business, that understands how you operate, will pay off every time.
Yeah, there's a couple of questions coming through. One thing I wanted to touch through before we get into that is the engagement of people that are those shadow or silent directors, the family members, or particularly, Dan, you and I have talked about this more than once, the patriarch or matriarch stepping away and then their kids run the business. They still just really, and Sally, Georgia, you've already touched on this, but they still need to be really actively involved, and we see that a lot in construction businesses where you're handing over the reins. Probably the messiest civil business I've worked with in the last 2 or 3 years, they innately trusted their son. They handed over the business to him. He signed a bunch of contracts. 40 years of a successful business dissolved within 6 months. So it is really important that those senior people, as they step back, still maintain that active role.
Definitely, and I think having an honest conversation as well. You know, sometimes people in those situations in succession planning and whatnot aren't cut out to be a director. And it is seen a little bit as particularly in family businesses, finally made, and I'm a director, I'm running the show. If they're not the right person, then you have to have that conversation with them. Then have that conversation with them, or speak to your advisors and get your advisors to have that, that uncomfortable conversation with them. Because sometimes, and in that situation you just said, Mike, if mum and dad resign and put the son on in that situation, but mum and dad are still calling the shots, well, then they're still liable because they're still a de facto director. Absolutely.
And I mean, one of the red flags we see is when the son, daughter, cousin, whoever it is that, or the person that's next in line comes in and suddenly disposes of all the existing advisors without good reason. And sometimes there is very good reasons for that. The existing advisors haven't been up to scratch, but when there's good advisors in place and people try and get rid of them, that's often a warning sign that things are about to go a bit pear-shaped.
Yeah, absolutely.
Something under the sheets is happening that people don't want to be aware of.
Absolutely, yes.
So the couple of questions, I'm going to start with Tony. Do these insurances cover you if you are actually negligent in your action as a director?
No.
Short answer.
Yeah, no, look, there'd be all sorts of there'd be carve outs for some of those insurances. And obviously if you're negligent, fraud, those situations, the insurance is not intended to cover those sorts of situations.
Very bad behavior is never really covered by insurance.
Yeah.
And that's, I guess, why you have a comprehensive policy and that benefit of engaging regularly with your business advisors. I guess that's part of the reason we've got Dan here today. Like I said, he's a frontline worker in this context. If you're engaging with them, regularly and meaningfully, you start to wipe out that risk of negligence because you are getting that sound advice like Sally, Georgia, and Dan have already spoken about. Next, yes, I saw the follow-up comment. Not that we're negligent, absolutely. The responsibility of senior management, can they be held responsible? That's a really good question from Jason. I'm going to throw back to the team there, but that's senior management. They are they can be in a very difficult position.
All right, I'll jump one in. So yeah, look, as we said before, it's not always a crystal clear question. If you've been appointed as a director, definitely yes, your director's duties are applying. You're in a bit of a grey area when you have people who are doing things like turning up to directors' meetings, voting on decisions, doing that sort of strategic thinking about how the business is going to operate. So if things are really clear, you have a board, you have directors, and then you happen to have senior management who are doing their job and following the directions of the board, you're probably looking pretty good. Things get a little bit messier when your documents aren't quite clear and you don't sort of have great paperwork around who's doing what everybody's roles are and who in fact is a director in your company. Do you have anything to add there, Sal?
No, I think that's right. I think maybe one other point is, if you're in senior management, even if you're not a director, if you're doing things that are fraudulent or negligent, you can still get in a lot of trouble despite the explicit director's duties not applying to you. So yeah, it's a question of what is that senior management person doing day to day? Could they be considered a director? And then, even if they're not, what are they doing and what are the possible implications outside the director's duties that could apply to that person, whether it's a, criminal offence, whether it's a breach of their employment agreement or breach of legislation or something like that.
It comes back to documentation as well. In that, we would usually suggest, even if that person has all but made the decision of what they're going to do, it still should have, in any business, no matter how big or small, still should have sign off from the directors. And that might be we've worked out how we're going to do this, how we're going to pay these people, structure this deal, whatever else, fire it off to the person who's actually supposed to make the decision and say, you okay with this, and get the email back that says approved, right? That is starting to have, whilst you haven't got a resolution, whatever else, I might have put it all together, but it's still a decision that's been made by the actual directors.
Yeah, I found, particularly in the construction context, working out, even as this is very much a stage one process, limits of authority. I've walked into a business before where they've got $500 million turnover and a junior project manager, so someone that's barely off a grad, could sign them up to a $20-30 million contract. So they had people with authority to do pretty well anything they wanted within that business. And surprise, surprise, a few heartaches started to creep in. It was resolved before it happened, but just even working out, okay, our junior project manager can sign up contracts up to a value of $50,000 because that's what they needed to do their day-to-day. And then working up that tree, and then suddenly the big documents, the big decisions started to make their way to the board when none of that was happening previously. So just little processes can sort of compound to have a really big impact. Also helps you identify people that need to get out of the business too when they're stepping outside of those roles. Okay, well, I think that's touched on touched on everything we wanted to cover. Sally, Georgia, Dan, was there anything else you wanted to throw out there, whether it's a war story or little tips of advice that people should take home with them?
But I know, I think it's always important, given that it's always there's a lot of negative stuff happening at the moment. The one kind of positive note: directors' duties are notoriously hard to become personally liable for. You've really got to do something properly wrong and know you're doing something wrong to become personally liable for it. The director's penalty notice, so the ATO stuff, is a little bit different. But the other stuff, provided you're documenting it, you're kind of doing all the right things, you're asking the right questions, those sort of things, you should feel fairly comfortable that you're not walking around with this huge liability on your shoulders. So I think it's, whilst we've told you all of the negative stuff and all of those sort of things, if you kind of think you're doing the right thing, then you're probably okay. But you'll know when you're doing something wrong.
Wonderful. Okay. Well, thank you, everyone. Thank you, Sally. Thank you, Georgia. Thank you, Dan. We'll have Matt Bryan and Chad Rapsey speaking this afternoon, really talking about expanding from what we've covered today, particularly around the restructuring and turnaround of businesses when they are in strife. And we do appreciate, particularly with the 2-week shutdown, if people are having cash flow issues, that might be a good time to, start having that conversation with your accountant or advisor. But if it gets a bit deeper than that, having insolvency experts is absolutely critical. Matt will be looking at it from the legal perspective. Chad will be giving probably his fairest share of war stories, but also some of the experiences he brings to the table with 20 plus years in insolvency. So that's 2 o'clock this afternoon. 10 a.m. tomorrow, we're going to try and do a wrap up of the week and try to cover kind of all the questions and bits and pieces that have been thrown to us that are sort of after the event. So things around what's been happening, what the orders from the government are. Dan, you and I have been talking about even this morning, the inconsistency of the government's approach. So do you want to just click to the last slide? So we've got some contact details there if people need it. So even the grants at the moment, just one more, I think. The grants at the moment, Dan, you're very much having to deal with that directly, but it's changing day to day, hour to hour, isn't it?
It is, yeah. So we've been, all of our contact with clients are saying this is correct as at now. But there was a change yesterday to the test period for some of those, for some of the grants. JobSaver, there's not enough information to be able to tell people how that's going to work yet. It's all a work in progress.
Yeah, so we'll try and wrap everything up as best we can tomorrow. We're sharing the contact details of everyone in our team and everyone that's taken the time to support us in these presentations as well. So Dan's obviously been a big part of that. But we had Bell Rock Insurance Brokers yesterday, and we'll have Chad this afternoon. So thank you, everyone. Anyone that needs to log in this afternoon, please do. And our details are there if you've got any questions or need any further assistance from Sally, Georgia, or Dan. So thank you all.
Thanks, everyone. Thanks, Dan.
Bye.
Thanks, guys.